pricing been set aside, Meghna, which means that petitioners who have been harping about pricing 40% greater than the previous UPA quote, etc., that has been completely removed, separated from the equation for now, which constitutes an advantage for the government, because this means now the arguments will be focusing on the procedure laid down by the DPP on acquiring these aircrafts and concluding the Rafale deal, which is where I have been saying for a while now that the government is most comfortable, because it seems to have a case which it can rely upon, because it has already produced material and handed it to the petitioners, suggesting that layers and layers of conversations took place within government to come to a conclusion that Rafale was the best aircraft for India. Now, I just want to quickly go across to Meghna. Meghna, more details coming in on the broadcast.
Well, absolutely, Rahul. In fact, one of the biggest takeaways, as you were rightly pointed out, is the fact that the Chief Justice himself has weighed in and saying that this argument is not going to be about pricing, and it is not going to be revealed in the courtroom till the court, and if at all, the court sees it fit. So if I can just go back across to Madhav Das Gopalakrishnan, getting us the very latest. Of course, we have our legal editor, Harish Nair, getting us details of what it means. Also, Madhav, we expect the government's case essentially to be that the petitioners may not be the right people to speak about the weaponry. When it comes to the procedure, we already have details, don't we, which have been emerging about how every rule in the book was followed to the T.
Well, you know, Prashant Bhushan had cited certain news articles during the course of his submissions to the Chief Justice's bench, where he had in fact said that there was a 40% markup or a 40% hike as far as the pricing is concerned. And that's what the AG has very vehemently countered in his own submission to the Supreme Court, coming out to say that blogs, media articles, all of this is the basis on which really the petitioners are coming out to submit before the Supreme Court. And this is not something that should be relied upon for multiple reasons, including the fact that these persons who are actually coming out to argue are not experts in the domain of defense. And really, of course, this requires the expertise of those who are involved in defense to actually come out and make these charges. So therefore, doubting the credibility of the claims that have been made by Prashant Bhushan, doubting the veracity of the items that have been used by Prashant Bhushan in terms of the news articles, blogs
from the court, the Attorney General also saying that secrecy not on the price of aircrafts but on weaponry and avionics. So the reason why the government is withholding information on the price from the public and not from the court, this must be made very clear here. The government has not withheld pricing details of also the avionics from the court. It has only not made it public because, according to the Attorney General, they can't renege. The government cannot renege on agreement with France to disclose confidential information on specs about avionics and weaponry. The moment a plane is acquired by itself, it is of no use unless it can have the right configuration of weaponry and avionics, because that is what gives it the edge over other aircraft that might be acquired by competing air forces in the neighborhood. And therefore, these details are usually kept secret, because if you make your avionics and weaponry public, then the adversary knows how best to counter you. It flows from logic. The government is therefore saying that we have no problem in sharing with you the details of the base price of the aircraft, but the avionics, the technology that makes it a fighting machine capable of inflicting damage on our enemies, that set of avionics cannot be disclosed, because that will be in violation of the agreement that we have signed with Dassault, and most importantly, give a strategic and tactical advantage to our enemies or those who want to engage us. And once again, the AG repeats, these are matters of defense, procurement and national security. There is no scope for judicial intervention or scrutiny. Petitioners should not have been entertained at all in the first place.